This is Matthew. He's a fictional character based on real court filings. In 2014, Matthew is renting an apartment in Salem, Massachusetts. Like thousands of tenants across the state, he pays an application fee just to be considered for the unit. Then, when he needs his locks changed, he pays another fee for that too. Both fees are illegal. Massachusetts has a law, General Laws Chapter 186, Section 15b, that spells out exactly what a landlord can and cannot charge a tenant. Application fees beyond certain limits. Lock change fees beyond actual cost. Both are violations. Matthew doesn't know this yet. Neither do thousands of other tenants who rented from the same company across the same apartment complex over the same years. But someone is about to find out. In July 2014, Matthew and another tenant file a lawsuit, not just for themselves, for everyone. A class action against the owner and manager of their apartment complex, a company called Lincoln Property Company, operating through two entities, Salem Station LLC and Lincoln Apartment Management. The lawsuit alleges the company has been charging illegal fees to an entire class of tenants across the state. Thousands of people, most of whom have no idea they were ever overcharged. This is where it gets interesting, because what happens next isn't really about Matthew or Lincoln Property or even the tenants. It's about what happens to money that nobody claims. Every class action lawsuit that results in a settlement creates a pool of money meant to compensate the people who were wronged. But here's the problem nobody talks about. Most people never file a claim. They don't see the notice. They move. They don't think it's worth the effort. They simply never know. So what happens to their share of the settlement? In Massachusetts, there's a rule for that. A specific procedural rule written into the state's rules of civil procedure that's supposed to make sure unclaimed settlement money doesn't just disappear or quietly flow back to the company that did the overcharging in the first place. That rule has a name. Rule 23E3. And in this case, that rule was broken. For 2 years, nobody noticed. Let's walk through what actually happens inside a class action lawsuit, because the process matters here. After Matthew's lawsuit is filed in 2014, it takes years to move through the system. The case is certified as a class action, meaning the court agrees that Matthew and the other named plaintiff, a woman named Olivia, can represent everyone who was charged these fees. Not just people in their building, tenants and prospective tenants across the entire state. Discovery begins. This is the part of a lawsuit where both sides have to hand over documents, records, communications, anything relevant to the case. And during discovery, something happens that becomes important later. Lincoln Property violates discovery rules. As a penalty, the court takes an unusual step. It precludes, meaning blocks, Lincoln Property from contesting certain facts about their own liability. In plain terms, the court essentially says, you don't get to argue about whether you did this. The evidence already shows you did. Both sides then file motions for summary judgment, asking the judge to rule without a full trial. The judge denies Lincoln Property's motion and partially grants the tenant's motion. On the core question, did Lincoln Property violate the security deposit statute by charging these fees? The answer is yes. That part of the case is over before it even reaches trial. But there's a second part of the lawsuit, claims under Massachusetts General Laws Chapter 93A, the state's unfair and deceptive practices law, that's still unresolved. And right on the eve of trial, with one issue already decided against them and a second issue hanging in the balance, Lincoln Property does what most companies in this position do. They settle. Here's where the story shifts from a lawsuit about apartment fees to a story about what happens to money that exists on paper but never reaches a human hand. The proposed settlement creates a fund, up to $4.16 million. That's $4,160,000, available to pay claims from class members. But here's the structural detail that becomes critical later. Lincoln Property isn't required to put $4.16 million into the fund up front. They're required to deposit $800,000 initially, just $800,000, with additional contributions only as needed, meaning only if enough class members actually file claims to require more money. This is a common structure in class action settlements. It's called a claims-made settlement. The defendant's actual liability depends entirely on how many people show up to claim their share. And in this case, almost nobody does. Before this settlement gets approved, a superior court judge, we'll call him the settlement judge, starts asking questions. Specifically, he's looking at one provision in the proposed settlement. A provision that says, if there's money left over in the fund after claims are paid out, some of that unclaimed money can revert, meaning go back, to Lincoln Property, the company that did the overcharging in the first place. The settlement judge has a problem with this. At not one, but two separate hearings, he tells the parties that a reversion of more than $700,000 back to the defendants would be unacceptable. He suggests $500,000 would be reasonable. The parties go back and revise the settlement. They cap the reversion at $500,000. Here's what's happening in this moment and why it matters. The judge is doing exactly what he's supposed to do. He's protecting the interests of thousands of absent class members, people who aren't in the room, who don't know this hearing is happening, who are relying entirely on the judge to make sure this settlement is actually fair to them. And there's a second issue the judge raises. What happens to unclaimed money that doesn't revert to Lincoln Property? Under Massachusetts rules, leftover settlement funds are supposed to go to nonprofit organizations or to a specific entity called the Massachusetts IWLTA Committee. IWLTA stands for Interest on Lawyers' Trust Accounts. The committee funds legal aid for low-income residents across the state. It's the kind of organization that exists specifically to catch money like this, settlement funds that would otherwise just evaporate or flow back to the wrong place. At the preliminary hearing, the parties propose a veterans charity as the recipient of any unclaimed funds. The settlement judge pushes back. He suggests, without endorsing anyone specific, that maybe a housing-related charity makes more sense. Or maybe the IWLTA committee itself. This is the moment. Right here. The judge says the words IWLTA committee out loud in open court during a hearing about this exact settlement. And under Massachusetts Rule of Civil Procedure 23E3, there's a very specific requirement that's supposed to follow from this moment. The IWLTA committee is supposed to be notified, not consulted, not given veto power, just notified, given a chance to show up and say, if there's money left over, consider us. It's a low bar, notice, and an opportunity to be heard. That's it. It doesn't happen. The settlement gets revised. The reversion cap goes to $500,000. The CyPres recipients, that's the legal term for where unclaimed charity money goes, end up being two affordable housing organizations, not the IWLTA committee, not the veterans charity originally proposed. In July 2021, the settlement gets final approval. The IWLTA committee is never told any of this happened. Now here's where the numbers get interesting. The settlement is approved. Notice goes out to the class, thousands of current and former tenants across Massachusetts who were potentially overcharged application fees and lock change fees. They're told, if you think you're owed money, file a claim. Time passes. By November 2023, more than 2 years after final approval, the claims process is essentially complete. And here's what actually happened. Approximately 220 people filed claims, out of a statewide class that likely included thousands of tenants. Total payments to the class, approximately $51,000. $51,000. Out of a settlement that was structured around a maximum of $4.16 million. So what happens to the rest? Under the approved settlement terms, here's the breakdown. The defendants had put $800,000 into the fund initially. After the roughly $51,000 goes to the 220 people who filed claims, and after the first $100,000 of unclaimed funds goes to the 2 housing charities as originally planned, what's left? Approximately $500,000 goes back to Lincoln Property. The company that illegally charged the fees in the first place gets back roughly $500,000 of the settlement fund, minus administrative costs. And the 2 housing charities? They split the remainder, approximately $124,500 each. In November 2023, the parties go back to court. Not the original settlement judge, he's retired by now. A different judge. They file a joint motion. They want final approval of this distribution. They want the case formally closed, dismissed with prejudice, done forever. And this is the moment the IWLTA committee finally finds out this case ever existed. December 2023, more than 2 years after the settlement was approved, after the claims process is already finished, after 220 people have already been paid, after the charities have effectively already been chosen, the committee gets notice for the first time. and they object. They argue, correctly, that Rule 23(e)(3) was violated. They were supposed to be notified before final approval, before the settlement judge made his decision about where unclaimed funds would go. They weren't notified at all until the entire process was already over. The new judge holds a hearing. The committee shows up and argues that the original approval should essentially be unwound, and the case reopened. The judge says no. She acknowledges, in writing, that yes, Rule 23(e)(3) was violated. The committee should have been notified and wasn't. But she declines to unwind a settlement that's already been approved, supervised by a judge for years, and almost entirely implemented. Final judgment enters. The case is closed. The committee appeals. This case goes all the way to the Massachusetts Supreme Judicial Court. The state's highest court agrees to hear it directly, skipping the usual appellate process, because the question at the center of this case is bigger than just one apartment complex in Salem. The question is, when a court rule designed to protect the public is violated, but the violation is only discovered after everything is already done, does that mean the whole thing has to be undone? In April 2026, the court issues its answer. And it's complicated. The court says, yes, the IWLTA committee has the right to appeal. Yes, the rule was violated. The committee should have been notified, and it wasn't, for over 2 years. But the court also says, even if they had been notified on time, there's no evidence in the record that anything would have actually changed. The settlement judge had already independently scrutinized the reversion provision. He'd already pushed back and gotten it capped. He'd already raised the IWLTA committee's name as a potential recipient, on his own, without anyone forcing him to. In other words, the system kind of worked, even when the specific rule didn't. The court affirms the judgment. The $500,000 stays with Lincoln Property. The case stays closed. But the court doesn't stop there. In the final pages of the opinion, the justices write something that reads less like a ruling and more like a warning aimed directly at every trial court judge in the state. They write that compliance with this notice rule is mandatory, not optional, not a guideline. And they instruct, going forward, that trial courts must address this rule explicitly at the settlement approval stage and confirm compliance before approving any settlement or entering any judgment where unclaimed funds might exist. Read between the lines, and what the court is really saying is this. This time, it didn't matter. Next time, it might. So what actually changed because of this case? A network of legal aid organizations, the Boston Bar Association, Greater Boston Legal Services, the Massachusetts Law Reform Institute, and others, filed a joint brief supporting the IWLTA committee's position. They understood something the original settlement process missed entirely. That $500,000 wasn't just an accounting line item. It was money that, under the rules as written, was supposed to have a chance of funding legal aid for low-income residents across Massachusetts. People who can't afford a lawyer when they're facing eviction or wage theft, or exactly the kind of illegal fees that started this entire case in the first place. Instead, it went back to the company that charged those fees. Not because anyone broke the law on purpose, not because of fraud or corruption or a cover-up, because one notice, to one committee at one point in a 2-year process, never got sent. And by the time anyone noticed it was missing, the money was already gone. The system has a rule for exactly this moment. The rule worked perfectly, except for the part where someone forgot to follow it.